Commonwealth of Massachusetts. Memorandum of Decision on Defendant's Motion to Dismiss. 269, Mass General Law, GL, General Law. 269, subsection 10A, is unconstitutional on its face. General Law 269, subsection 10A, is unconstitutional as applied to the defendant. General Law 269, subsection 10A, violated the defendant's right to be free from cruel and unusual punishment. The link is in the description. Conclusion. Let me try zooming in one more time, see what happens. Yeah, we can make it fit. Boom. A law-abiding resident of New Hampshire who is exercising his constitutional right should not become a felon by exercising that right while he is traveling through Massachusetts merely because he has not obtained a Massachusetts license to carry, which now, under the holding of Bruin, has to be issued to an applicant unless the applicant is otherwise disqualified. The standard for who is a disqualified individual must be the same. Otherwise, a state may decide to impose different requirements on the exercise of a constitutional right. For example, some states could impose different age limits on voting in elections. This court can think of no other constitutional right which a person loses simply by traveling beyond his home state's border into another state, continuing to exercise that right, and instantaneously becomes a felon subject to mandatory minimum sentence of incarceration. Anecdotally, a law-abiding New Hampshire resident exercising his constitutional right to carry while shopping at the Pheasant Tree Mall in Nashua, New Hampshire, would become a felon when he shops in the section of a store at the mall, which happens to be in, I'm not even going to try to pronounce this, Massachusetts. Tingsboro, I guess. An individual only loses a constitutional right if he commits an offense or is or has been engaged in certain behavior that is covered by 18 U.S.C. section 922. He doesn't lose that right simply by traveling into an adjoining state whose state mandate that residents of that state obtain a license prior to exercising their constitutional right. To hold otherwise would inexplicably treat Second Amendment rights differently than other individually held rights. Therefore, the court finds General Law 269, subsection 10A, as unconstitutional as applied to this particularly situated defendant and allows the motion to dismiss on those grounds. Signed, John F. Coffey, Associate Justice, dated 8/3/23. I know of 11 Moors who were traveling from one state that did not require a license to carry, that did not require an FID card to possess ammunition, that did not require a license to possess quote-unquote high-capacity magazines, which are standard. 30-round magazines are standard. Nor did they require the 100-round drums that they sold in Cranston. They didn't require a license for those things either. They didn't require a license for the 50-round drums that they sold in Pawtucket, Rhode Island. nor, like I said, the 100-round drum that they sold at a store that anyone can just walk into in Cranston, Rhode Island. They didn't require a license for those things. And then those 11 Moors who were going from one state that didn't require those things to another state, Maine, that also didn't require those things, were confronted by a potential threat and then charged with this same statute. But this judge is saying it doesn't make sense that by simply exercising your constitutional rights, you become a felon. You know what was also interesting about this statement? Is that when you read the case, the guy, Dean F. Donnell, stated that, well, in my home state, New Hampshire, you don't need a license. And that was the rationale that was used for this decision. Look it up. That's why it explains how he had the right to exercise this right in his own state. It doesn't make sense that he becomes a felon here. You know what's also interesting about this? One of the 11 Moors that were arrested July 3rd, 2021, for this and charged with the same thing, also said this. Not only did he say it when the police asked, do you have a license for these quote unquote firearms? The response was, in Rhode Island, you don't need one. And in the state that we're going to, you don't need one. Those same people were still arrested. And then even more interesting is that this same argument was made in front of James Boudreaux, a so-called judge of the Massachusetts Superior Court. And his response was, you're misinterpreting the Second Amendment. You're misinterpreting the law. Then Bruin came out and affirmed that the Massachusetts statute was unconstitutional. Requested a hearing on it. He said no. Now this came out, which already re-argues what I already argued. Yet this guy gets the dismissal and 11 Moors don't. I wonder why. I wonder what this man looks like. I wonder what his skin color is. How come he's not called a sovereign citizen? Why are his rights protected more than 11 other people? The court can think of no other constitutional right which a person loses simply by traveling beyond his home state's border into another state, continuing to exercise that right, and instantaneously becomes a felon. Now, let me show you something. Please bear with me, because I was gonna make this short. Let me show you something. Let me show you something. One second while my computer decides to load. Oh, look, it somehow signed me out of YouTube. So I might not be able to show it. Let me see. Oh, wow, it signed me out of Gmail too. All right, well, we'll just keep reading this over and 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 over again. Let me go back up to the reference. Just so you can see for yourself. Memorandum of decision on defendant's motion to dismiss. (269) subsection 10A. It's unconstitutional on its face. On its face, meaning just by looking at it. Just by looking at it, it's unconstitutional. Then, when you apply it to this individual, it's unconstitutional. Then when you apply it to the Eighth Amendment, it's unconstitutional. How is it that 11 Moorish Americans, at least one of them, and I know the person very personally because it was me, argued the same thing in front of Boudreaux? I argued that it violates the Constitution because there's no mens rea. It violates the Constitution because there's no corpus delicti. And it violates the Constitution because it's not a crime. And I even clearly explained how murder in Rhode Island is murder in Massachusetts. Because murder is a crime, period. It doesn't matter where you go. Then I specifically said it doesn't make sense that if I walk from Pawtucket to North Attleboro, which I can just go up one street and get there, that if I have one leg in Massachusetts and one leg in Rhode Island, I'm a felon on one side and not on the other. I made the same argument. Look it up. I actually hand wrote it while I was in jail. Hand wrote the same argument. The same exact thing. The same exact thing, that there's no other constitutional right which a person loses by simply going to another border. I made the same exact argument, and Judge James Boudreaux of the Woburn, Massachusetts Superior Court said I was wrong. I'm a sovereign Moor. I claim to be a sovereign citizen. I'm claiming that the government's laws don't apply to me. I'm misinterpreting the law. I'm making stuff up. That was his response. He did not address not one thing I said. Then I filed a motion for reconsideration. Judge Deacon said he's not going to rehear what Boudreaux heard. So he assigned it, or he left it up to James Boudreaux's discretion, and he denied hearing it again. Yet here we are again for the second time, proving that another judge, first the Supreme Court, now this Lowell judge, is agreeing to what I already said. I've already said it. Already, meaning it was already said. I already said it previously. Before this date, I said it. In fact, I said it while I was in jail. Then, the next day, the day after James Boudreaux's decision, the United States Supreme Court ruled that the Massachusetts statute was unconstitutional. The next day. Then he recently denied to reconsider it. Now this. Again, another judge that recognizes the laws of the United States, since they're claiming I don't. This judge must be a sovereign citizen more. He must be. Because he's saying the same thing I was saying, and when I say this stuff, they call me a sovereign citizen. So this judge must be a sovereign citizen. And actually know more that has been before this judge. Matter of fact, let me text him. Let me send him this. Let me send it to him. Let me go back to where it says it's unconstitutional so you can show your friends. If you have any friends who are sitting in jail, I was in jail with people that were pending gun charges for 5 years. Well, they were in there for 3 years. It's basically 5 years. Pending trial for gun charges. Nobody was shot at. Nobody was threatened. Nobody was harmed. There was no shootings. There was no threatened shootings. Nothing. And they're just sitting in jail waiting trial for 2.5 years. And if I'm mistaken, 1.5 years. And then I'm pretty sure the mandatory minimum is 2.5 years. So they're already 1.5 years in. Guess what they're going to be presented with? Well, if you take this deal, you get to go home now. Time served. Guess what most people are going to do? just to go home. They've been in jail for so long. They want to see their wife. They want to see their mom. They want to see their children. They want to see their cousins and brothers and sisters, and they want to have fun. So guess what they're going to do? On the threat, duress, and coercion, they're going to say, you know what? Even though I have an attorney and he's not advising me of my constitutional rights, I'm going to take this deal so I can go home. I'm tired of being in jail. And then there's more out there that are just crazy saying, oh, everyone that's in jail is there by choice. All they have to do is issue out a thing against the bond and claim the QSIP number and claim they're full of crap. This is real life. Real life. Not pretend in your mind. You're going to court in your mind only. The only thing that you got dismissed was a parking ticket, which they got TV shows about a judge in Providence, Rhode Island, where he just gives everybody a break. They don't use more science. They don't even have an attorney. It's a TV show. He's a real judge. They walk up, they joke, and then he says, dismissed. Sometimes he'll issue a fine. Sometimes he'll make it seem like, oh yeah, I'm going to be strict on you. I'm going to be hard on you. People get traffic tickets, parking tickets, red lights, speeding tickets, dismissed all the time. We're talking about real life, real oppression, serious charges that they're just, 88 years for conducting your second, for exercising your Second Amendment right. That's crazy. Yet here's a judge. Based on this decision, this seems to be a fair and honorable constitutional decision that people have been arguing for years, that it's unconstitutional. As a matter of fact, Shelburne Police versus Mayor in the Commonwealth of Massachusetts, they said that there is no individual right to keep and bear arms. Therefore, to license it is not unconstitutional. Then, the United States Supreme Court in 2008 said there is an individual right to keep and bear arms, which means what? To license it is what? I'll let you figure that one out because it's so deep and metaphysical. This is crap. The reason why it's crap is because people are being injured. The defendants, most of the time, 99% of the time, from my experience, they just had possession of something. There was no intent to hurt anyone. There's no intent to rob anyone. No intent to take anyone's life. No intent to do anything except for what? Defend themselves. As a matter of fact, let's see what the United States Supreme Court said. In District of Columbia versus Heller, the Supreme Court undertook its first ever in-depth examination of the Second Amendment's meaning. After a lengthy historical discussion, the court ultimately concluded that the Second Amendment guarantees, guaranteed, which means you don't need permission, which a license is permission. I'm sorry, let me zoom in. It doesn't look like you can see it. Let me know if you can see this. It doesn't matter. I'm reading it to you anyway. Guaranteed, 100% guaranteed, the individual right to possess and carry weapons in case of confrontation. So if you have the guaranteed right to carry this in case of confrontation, why would you need permission? That is central. That central to this right is the inherent right of self-defense. It's inherent. 1 second. Peace. Yeah, and that was the judge you was before, right? I remember you mentioned his name, Coffee. Yeah. Yeah, this is in Lowell, yeah. Lowell, Mass. Actually, a random Moore sent it to me on Instagram. The decision was 8/3/2023. John F. Coffey, your boy. Yeah, saying the same shit I've been saying. Saying the same shit we all been saying. I'm live right now, by the way. Heck yeah, it's good. And as soon as I got it, well, not as soon as I got it, I just finished writing. This is what I called it officially. I called it the emergency motion to dismiss based on new decision, even though I've already made this argument. That's what it's officially called. Yeah. Yeah. And they, bro, I literally hand wrote this in jail and had this same argument before James Boudreaux, and he said, "Nah, you're misinterpreting the Second Amendment. Nah, you're a sovereign citizen rhetoric, and you're saying the government's laws don't apply to you, and you're anti-government." Yeah, exactly. And he signed it, and he's actually signed. These judges don't be signing nothing. Facts. So on YouTube. Yeah, peace. Anywho, this is also from the United States Supreme Court. United States Supreme Court. Peep the date. The same date our holy prophet was alive, living, breathing on this planet. Breathing. Alive. Let's go to the opinion of the United States Supreme Court. Not my opinion, the opinion of the United States Supreme Court. Opinion of the United States Supreme Court. The framers of the Constitution recognized the distinction between the Republican and Democratic form of government and carefully avoided the latter, which means they carefully avoided a democratic form of government. This is the opinion of the United States Supreme Court in 1912. Anyway, this is what I sent to the standby counsel. As a matter of fact, I will show you what I sent. Let me hold on one second. Where's this thing at? Where's it at? We'll do this. All right, just in case. Where's it at? I think it signed me out of Gmail. I don't know why it keeps doing this. I find it offensive. Let's log in. I'm not going to read what he wrote. I'm just going to read what I wrote, just to kind of respect the quote-unquote attorney-client privilege, which is bullcrap. And you'll see the time and date. It says 44 minutes ago. Boom, right here. This is the email I sent to the standby counsel. Right? That's his name right there, so you can see I ain't making it up. 44 minutes ago. You can see right there. I'm not making it up. I just found out about the Donnell decision today, and I would like to file an emergency motion to dismiss. It's officially titled Emergency Motion to Dismiss based on new decision, even though I've already made this argument. I'm requesting to have this hearing on December 24th or December 25th, 2023, or sooner. Please file it with the clerk and notify Van Epps, who's the prosecutor. In accordance with General Law 220, subsection 6, the courts of the Commonwealth must be open for court business on all days except Sundays, Saturdays, Sundays, and legal holidays. And this is from their website, which you can see at the bottom. It just popped up. I'm not sure if you see it. I can see it on mine. I know you can't see it on yours. It's mass.gov/info. I'll just do this. We'll just stop this around. We'll just do that. Right there, mass.gov. You see it at the top. Mass.gov. You already know. Anyway, I know of no laws that list December 25th or the 24th as a legal holiday, which means that there has to be a statute, public law saying that it's a holiday, right? Legal holidays. And if there are, please cite the U.S. Code or statute. I'll try to contact you Monday via telephone because he said something about 7 cops in my case or they violated something. I don't really know. And I said, please file the appeal because there's a... I already talked about this before. I only got 2 minutes left. The judge in Lucha's case made a decision based on an argument that was made by Van Epps in Massachusetts, even though this is a federal judge in New York. So I already know they're in cahoots. So I already filed an appeal to this decision that hasn't been made yet. And in his email today, what's today? 8/25/23, there still has been no decision yet. And the judge only has 30 days to make a decision. Anyway, if you won't if you don't do it, let me know in writing so I can file it myself. I just figured I can save money by sending it to you digitally, and since you are an officer of the court and your first obligation is to the court and not me, and you get paid to do this, I figured I can make my life easier pending 88 years imprisonment by having you do it for me. Smiley face. Corpus Juris Secundum, Volume 7, Section 4, Attorney and Client. The attorney's first duty is to the courts and the public, not to the client. And whenever the duties to his client conflict with those he owes as an officer of the court in the administration of justice, the former must yield to the latter. Respectfully sent me today, 47 minutes ago. So I got it today, wrote a response today. In the interest of my rights and the principle of those who do not enforce their rights have none, I must reassert my argument that the charges I am facing violate my constitutional rights. Although I've already argued this before the court. Judge Coffey wrote on August 3rd in the Commonwealth of Massachusetts, versus Dean Donnell, that it's unconstitutional. The police and prosecutor in this case and the evidence presented before the court asked if I had a license. At the time of the arrest, July 3rd, 2021, in Rhode Island, a license was not necessary to open carry. And I responded, similar to defendant Donnell, that in Rhode Island, you don't need a license. The 30-round plus magazines and ammunition were also lawfully purchased in Rhode Island without requiring a license or FID card, as well as the fact that all of the arms I personally own have been purchased after a state and federal background check, which proves that I am not a criminal prohibited from carrying arms. We were also going to another state with the same or similar rules, Maine, and video evidence was already submitted regarding an armed patrol we conducted in Pawtucket, Rhode Island, open carrying arms, and the police did not arrest us while we were in our militia gear. None of the defendants here are residents nor citizens of the Commonwealth of Massachusetts, thus making us similarly situated to the defendant herein. We were traveling to and from a state that did not require a license to carry, nor do they prohibit 30-plus round magazines, nor do they prohibit ammunition without an FID card. And en route, we were confronted with a potential threat to our lives, making our conduct fall within the scope of the Second Amendment. Moore versus Madison. Armed self-preservation is a fundamental natural right. A right to possess guns for resistance, self-preservation, self-defense, and protection against both public and private violence. The United States Supreme Court, District of Columbia versus Heller. The Second Amendment guarantees the individual right to possess and carry weapons in case of confrontation. Copious amounts of case law was provided to support this claim, along with the facts of the case and our particular circumstances. This same argument was already made before Justice Boudreau. The same argument Donnell made, yet mine was dismissed as frivolous or I was misinterpreting the law. In the same manner, the Supreme Court ruled the Mass statute was unconstitutional. I asserted the same opinion, to which Boudreau denied it with the above flawed rationale. Yet again, here I am, arguing what I've already argued and appealed. This is why I requested a new hearing, but Boudreau denied it. Only for another judge in another case to rule in favor of the same argument I've previously made. There's clearly a problem here, and clear prejudice against me. For the reasons stated above and previously before Boudreau, and the reasons stated in Donnell, this issue must be dismissed for violation of the Second Amendment. These arguments were made in district court, on the highway before our arrest, and several times in court during motions hearings. Yet, here I still am, facing 88 years for doing what was legal in my state of origin and my final destination. I was simply held hostage by the Mass state troopers and arrested for exercising my rights. And then a picture of the decision from the judge, signed by the judge. Peace, Moors. Don't give up. Keep fighting oppression. It doesn't matter what they say. Oh, my bad. None of that was even seen. Oh, well. I read it to you. It doesn't matter. Keep fighting against tyranny. Keep resisting against terrorism. Be patient. Don't fold just because they're threatening you. Where do you know these people are terrorists? That's why most of us woke up in the first place. We knew something was wrong. More science explained it. Why give up now? Allah tells us in His holy books that what? That He's going to test us to see who's the true believers and who's not. That Allah will never change our conditions until we first change what is in ourselves. So we can't fear a colonist and then say, we want our land back. We want our rights back. But then anytime they scare us, we just fold like lawn chairs and give ourselves up and write statements against each other. We can't do that. If we continue to do that, we'll never be free. So be a man. Stand up for your children. Stand up for your spouse. Stand up for